Welcome everyone, both in the room and those attending remotely to this morning's breakfast briefing, which concerns issues dealt with in my new book, A Practitioner's Guide to Correcting Pension Schemes Mistakes, which is published by Bloomsbury Professional. Looking back at how the courts have approached attempts to correct pension scheme mistakes, it's easy to characterise them as a series of missed opportunities. For example, English judges have could have taken a liberal approach to the treatment of formalities in amendment powers, but unlike their Scottish counterparts, they instead have insisted on construing them very strictly on the rather questionable basis that it's of particular importance for members that those formalities be complied with. Another example was the use of the rule in Hastings-Bass as an alternative to rectification of pension scheme provisions. This became sufficiently established in the early noughties as to be amenable to summary judgment, but its use was put to an end by Smithson and Hamilton, such that it's now of historical interest only. And a third example has been a failure by courts to develop the law of estoppel, particularly estoppel by convention, in such a way as to give legal effect to long-held assumptions by trustees, employers and members that an amendment to a pension scheme has been validly made. As a result, there are sections of my book which deal with ways in which pension scheme mistakes cannot be corrected by a legal process, which at first sight look as though they could be of assistance. However, the focus of the book is on how mistakes can be corrected rather than how they can't be corrected. And this broadly involves two approaches. First is to consider ways in which the correction of future errors can be facilitated by drafting techniques. And the second is to identify the situations in which the courts have helped rather than hindered the correction of pension scheme mistakes. And this morning's talk concentrates on the latter approach. Jenny and I will go through some of the ways in which the courts have assisted in correcting pensions errors. And in particular, we're going to look at 6 topics. I'm going to begin by considering how the lack of evidence of an intention to exercise a pension scheme power may be overcome by the use of presumptions. Jenny will then consider how the courts have acted to hold valid parts of amendments that would otherwise be invalid. I'll then look at the principle of corrective construction in the field of pensions. Jenny will then look at the use of summary judgment process to rectify pension scheme mistakes. I'll then look at the use of the maxim, equitable maxim, equity treats as done that which ought to be done. And Jenny will conclude by looking at South West Trains contracts. And at the end of this talk, we'll be taking questions both from the floor and online. And if anyone attending online has any questions or comments, please use the Q&A function. So I will start off with the presumed exercise of power. Now, one of the requirements for the valid exercise of a pension scheme power is an intention by the holders of the power to exercise it. Usually this intention is manifested by a recital in the relevant document recording the exercise of the power. But what if the wrong power is referred to because, for example, the parties mistakenly overlook the fact that the recited power had been replaced? Or what if the parties seek to exercise a power which can only validly be exercised if a different power had already been exercised? The first case in which this issue arose in a pensions context was Davis and Richardson Wallington. In that case, 2 scheme deeds have been executed by the employer and 2 of the 3 trustees in circumstances where everyone had wrongly believed the 3rd trustee had validly resigned. The judge held the deeds were validly executed on the basis that the employer had the power to remove the 3rd trustee from office and could properly have exercised the power to bring about the result contemplated by the 2 deeds. The judge presumed the requisite intention by the employer to remove the 3rd trustee, even though it wasn't possible to infer the exercise of the power on the facts. So, where a pension scheme power is purportedly exercised by the requisite document, the absence of any reference in that document to the exercise of the power won't be fatal, as the court will presume that the power was exercised, even where an intention to exercise the power cannot be proved. Moreover, if for whatever reason it lies within the capability of those who have purported to exercise one power to confer that power by first exercising another power, the principle will be applied to presume the exercise of both powers. In other words, in the Davis and Richardson Wallington's case, the power to remove trustees and then the power to amend. Now, this is a rebuttable presumption, which can be displaced if the evidence shows that the people in question had a positive intention not to exercise the relevant power. However, and importantly in the pension scheme context, it appears from the Capital Cranfield Trustees case that an intention not to exercise a power will not be established where the document records the wrong power simply rather than no power at all. So in the example I just referred to of the superseded power, the mistaken reference to that superseded power in the recitals will not rebut the presumption that the parties intended to use the correct power. A good example of the use of this presumption is the Coates UK Pension Scheme Trustees case. In that case, a deed purported to make a change which fell foul of a proviso to the scheme's amendment power, which would have been permitted by an application of the statutory provisions to modify schemes in section 68 of the 1995 Act. Court held that the parties to the amendment were to be presumed to have exercised the statutory power, even though the deed itself only referred to the exercise of the scheme amendment power. Now, the presumption, however, has limits. In Briggs and Gleeds, the judge said that the presumption couldn't be applied where there was a doubt as to whether the parties would have chosen to exercise the power had they taken into account matters relevant to its exercise, which were not also relevant to the power they believe themselves to be exercising. And in the same case, the judge said the presumption would not normally be applied unless it allowed the whole of what the relevant decision maker was trying to do to be achieved. So where the decision involved a set of changes, the principle can't be used to salvage some changes but not others, because it may well have been possible that the changes were intended to be made only as a complete package. And in the Capital Cranfield Trustees case, the judge doubted whether the principle could apply so that a person purporting to exercise a power in the wrong capacity could be presumed to have acted in the capacity which would validate the exercise of the power. And in Burgess and Bick, the Court of Appeal refused to presume an intention to make an amendment at a time when the necessary power to do so had only been introduced into the scheme after the amendment in question had been made. Now, notwithstanding these limitations, this presumption has proved to be of great practical use in situations where changes have been made to schemes by the use of the wrong power. I'll now hand over to Jen.
Thank you. So the second example of when the courts have come to save the day is when a pension scheme is amended in a way which is partly valid and partly invalid. So, for example, because you've got an amendment which goes beyond the terms of what's permitted by the amendment power. So to give a factual example, imagine you've got an amendment where someone purports to amend benefits accrued in the past as well as in the future. The benefits that have accrued in the way it affects benefits accruing in the past is often against the terms of the amendment power. And in this case, the courts have been prepared to limit the invalidity to the part of the amendment which goes beyond the amendment power to enable the rest of the valid amendment to operate. The courts have tended to approach this task in one of two ways. The earlier cases approached it by way of construction. So they read into the amendment the restriction in the scheme's amendment power. So the amendment was only valid to the extent that it didn't infringe this implied restriction. The second way the courts have approached this is by the doctrine of severance. And this is what the later cases have used, which enables the excess and the non-excessive exercise of the power to be severed from each other. An example of an earlier case which looked at this principle by way of construction is the case of Doyle and Manchester Evening News, which was decided in 1989. That involved a retrospective amendment to a pension scheme, which sought to exclude an element of members' earnings from being part of their salaries for pension purposes. This was held to have infringed a proviso to the pension scheme, which prohibited an amendment which prejudiced its pensions already in payment. Now, the retrospective element of the change would have affected the pensions in payment of two members, and it was argued that this infringement rendered the whole amendment invalid, but this was rejected by the judge. He said the effect of the provisions is simply to exclude from their effect pensions already being paid. The proposed amendment is valid in general, but does not affect the two pensioners whose interests are already vested. So there the court was treating the matter as one of construction, which required the restriction in the amendment power to be treated as if it was part of the amendment itself and limited the operation of the amendment to comply with that restriction. It doesn't appear to have been done by way of implication of terms because the judge didn't look at what was of what would be obviously agreed between the parties, or a business efficacy test, apologies, but instead the restriction was simply read into the amendment as a matter of construction, and they ignored how that technically worked as a matter of law. Now, an example of the court applying the severance principle to save the valid part of the amendment is in the case of Bez Trustees and Stewart, and that was a decision of Mr. Neuberger in the High Court in 2001. There, the trustee and the employer wanted to increase the normal retirement dates for female members from 60 to 65 following Barber, and the announcement purported to apply to benefits accrued in the past as well as future service. The scheme was in wind-up, and the trustee sought directions from the court regarding the corrective interpretation of the announcement, which was purported to change the NRD for females. Now, the scheme amendment power contained various formality requirements, including the requirement that any amendment need to be made by way of declaration, and also stated that no amendment can affect prejudicially the accrued rights in respect of pension benefits accrued to any prospective beneficiary. Mr. Justice Neuberger first found that the announcement failed to comply with the scheme's formality requirements because there was no declaration. However, in any event, he recognised that there was a small retrospective increase in the normal retirement date for women between a period of the 6th to the 26th of April 1994, which would have fallen foul of the amendment power. But Mr. Justice Neuberger said that if that was the only problem with the amendment, he would have still held that it didn't prevent the announcement from taking effect. It's just that it was only going to take effect prospectively from the 26th of April. And in reaching this decision, he quoted from Thomas and Powers and Farwell and Powers, looking at excessive executions of power. So powers which are in excess of the scope of the power or otherwise in breach of a rule of law, and held that if the effect of an excessive execution means that it is otherwise good in part but bad in part, then it's just the bad bit that should be void, as that was a distinctive element. Now, he identified two requirements for the operation of the severance principle in this context. First, is the valid and invalid exercise of the power conceptually different, and is it easy to make that split? And it is in the case of retrospective and prospective exercises of power, so it is easy to sever off the excessive execution. The second requirement stems from the case of Re Hastings Bass, and there the trustee needs to consider, and the court needs to take into account, whether the trustees would have acted differently if it understood that it was not entitled to exercise the power retrospectively. Would it have exercised the power as it purported to do so at all, or in the way that it did? Now, Neuberger didn't consider the construction principle, and the earlier case of Doyle was not referred to by him. Subsequent cases have applied the severance principle and the construction principle, and I won't go into them in detail now, but I just wanted to finish by looking on the latest case in this topic, which is Wedgwood and Salt. That was a decision of Deputy Judge Penelope Reid in January 2018. There, the amendment in question wasn't prejudicial to accrued rights per se because of an amendment to those rights themselves, but because of the impact on the value of those rights by way of an extension to the ability of the employer to participate in the scheme. So the employer tried to serve a notice terminating its contributions under a rule introduced in 2001. And the question in that case was that rule introduced in 2001 valid? Because it amended a predecessor provision, which only allowed an employer to terminate its contributions when that was impracticable or inexpedient. Now, the deputy judge said that the answer was the same, whether looked at as a matter of construction or as a matter of severance. She held that the rule introduced by the amendment in 2001 was subject to the implied limitation that the employer could only terminate contributions where it was shown they'd found it to be impracticable or inexpedient to participate in the scheme. So she introduced the earlier limitation in the amendment power into the operation of how the employer could terminate its contributions. She also held that the Hastings-Bass requirement, so whether or not the person amending the scheme would have acted differently if they knew to the extent that they were unable to act contrary to the amendment power, had to be complied with, but without the gloss that the subsequent case of Pitt and Holt had put on it, which required a breach of fiduciary duty. There's various problems with introducing the Hastings-Bass requirement here, which Paul flags up in chapter 4 of his book. But notwithstanding that, here we have an example of the court trying to save the valid exercise of an amendment to a pension scheme, whether that be by way of construction or severance. Thank you.
So, corrective construction. After years of toing and froing on the subject, it's now been established that where a document is clear and unambiguous on its face, the court will not apply a strained construction to read the document in a different way, irrespective of whether that literal reading lacks common sense. In that situation, however, it's still possible to apply what's called the principle of corrective construction. The application of the principle has the same effect as rectification, so that the provision in question is treated as having always been in the corrected form. And this principle has considerable practical advantages over rectification, in that it doesn't necessarily require court proceedings, and even if proceedings are required, they'll generally be cheaper and quicker than a rectification claim. Now, this principle originally existed to deal with blatantly obvious typographical errors and omissions, and for many years the jurisdiction was exercised very sparingly in circumstances where the mistake was purely clerical in nature. Moreover, the mistake had to be apparent from the document itself, and extrinsic evidence was inadmissible for this purpose. However, the principle has now developed and was authoritatively restated by Lord Hoffman in the Chartbrook case in this way. He said it will be applied where it's clear that something has gone wrong with the language, and it's clear what a reasonable person would have understood the parties to have meant. He said in order to establish the mistake, the court is not confined to reading the document without regard to its background or context, and there is no limit to the amount of rearrangement or correction which the court is allowed when applying the principle. And the Supreme Court in Barnardo's and Buckinghamshire confirmed that the focus on the language of the provision rather than the factual background doesn't preclude the application of the principle of corrective construction. Now, whilst I've said the principle is a valuable practical alternative to rectification, it isn't a complete substitute, as there are a number of limits to its application. In both corrective construction and rectification cases, the court begins with the presumption that the words used in the document constitute a true and accurate record of what the parties intended to say. So as with rectification, it requires a strong case to persuade the court that the corrective construction principle should be applied. Indeed, in one case, the Network Rail Infrastructure case, the court went so far as to say that a higher standard of proof than the usual balance of probabilities was necessary, and the court had to be sure that there must have been a mistake. The threshold test for corrective construction is also stricter than the test for rectification. For rectification, it's enough that the wording of the document is contrary to the common intention of the parties. But for corrective construction, the court must be satisfied that something has gone wrong with the language the parties have used, as opposed to the implementation of the bargain or the decision to exercise the power, which in turn requires, according to the Honda Motor Europe case, the result to be irrational, absurd, or nonsensical. So, a failure to think through the consequences of the provision, as opposed to any deficiency in its drafting, will not bring the corrective construction principle into play. It isn't enough that the document is unfavourable to one side or another, and it isn't enough that the wording makes the arrangement more difficult to operate. The next limitation relates to the scope of the admissible evidence. Because the process of construction is an objective exercise and can be contrasted with rectification, where it's what the parties themselves thought the document meant to achieve that's relevant, the evidence the court will admit to establish the mistake in the correction in a construction case is narrower than is permitted to establish the mistaken intention in a rectification case. So rectification is the only available remedy if there's only evidence of subjective intention. And a court of construction can't take account of pre-document negotiations or of any matters subsequent to the execution of the document, such as how it's been operated by the parties. whereas by contrast, evidence of both of those is admissible and often highly relevant to rectification cases. In practice, a successful construction claim will be based on extrinsic objective evidence, such as previous versions of deeds, draft deeds, and commentary on those drafts, together with a sufficiently strong case based on the implications of the literal reading of the document in order to overcome the exacting threshold test. Finally, although, as Lord Hoffman stated in Chartbrook, there are no limits to the amount of correction which can be made, the court will not, as a matter of construction, read into the document a whole term omitted in error, where the document makes sense without it. And a good illustration of this is the Cherry Tree Investments case. In that case, the Court of Appeal was asked to construe a legal charge to include an enlarged power of sale for the mortgagee, which hadn't been expressly set out in the legal charge itself, but which had been set out in the terms of a related facility agreement. And a majority of the court refused to read that power into the charge because it involved reading an entire provision which had been omitted by the parties into a document, which made perfect sense without it. That was considered to be beyond the correction of what the parties had put into the document and amounted to a rewriting of the contract to include something which had never been there, which was regarded as the exclusive province of rectification. Finally, I want to look at a couple of pension scheme cases where the corrective construction principle has been applied to contrast the different approaches in those cases. The first case is Sterling Insurance Trustees Limited and Sterling Insurance Group Limited. This case concerned the meaning of the words accrued due in a restriction in an amendment power, which prohibited amendments which operate so as to substantially reduce in aggregate the value, as to which the decision of the trustees acting on the advice of the actuary should be final, of the benefits accrued due in respect of any member up to the date of such alteration, modification, or addition. The question was, did that restriction protect all past service benefits, such as to prevent an amendment which sought to break the final salary link? The judge accepted the employer's argument that on its true construction, the natural and ordinary meaning of the phrase accrued due was limited to benefits which had fallen due for payment, and so didn't include accrued benefits in the sense that we would naturally take that. However, the judge adopted a corrective construction to the phrase in the context of its use in the amendment power and disregarded the word due, so that the restriction applied to all accrued benefits and therefore on the courage principle applied to protect the final salary link. And he did so principally on three grounds. The first was the practical effect of the employer's construction would have been to give the protection very little limited effect. And it was unlikely the drafter would have gone to the trouble of protecting a payment which the trustees should already have paid. Secondly, the judge said that Section 67 of the Pensions Act 1995, which was in force at the time of the introduction of the amendment power, already protected changes to benefits which had become payable. So there was a complete overlap between Section 67 and the literal meaning of the scheme amendment power. And thirdly, he said the references in the provision to acting on actuarial advice, the aggregate value of the benefits, and the need for substantial reduction to the benefits pointed away from the drafter having envisaged a payment which had already fallen due. Now, in my view, this decision represents a significant extension of the corrective construction principle. The judge didn't rely on the absurdity or illogicality of the provision. On the contrary, he accepted that on its literal construction, it was capable of operating according to its terms. The judge instead corrected the provision as a matter of construction on the basis of the impractical consequences of its limited application. And this is arguably a relaxation of the threshold test I referred to earlier, and an application of the principle to a case where the wording merely made the arrangement more difficult to operate. That case can be contrasted with Britvik plc and Britvik Pensions Limited. That case, a scheme provided for a pensions increase cap of a prescribed rate, quote, or any other rate decided by the principal employer. The issue was whether the prescribed rate could be replaced by any other rate or only by a higher rate. At first instance, the judge construed the phrase any other rate to mean only some other higher rate and not a lower one. Alternatively, if that phrase couldn't be construed in that way, the judge said that he would have adopted a corrective construction on the basis that an objective observer with full knowledge of the admissible background, would have been clear as to what the nature of that error was and how it should be corrected. However, the Court of Appeal reversed that decision, focusing on the unambiguous language of the phrase any other rate, which didn't naturally mean any higher rate. The master of the rolls in that case held that the process of corrective construction was only normally adopted in the case of an obvious mistake on the face of the document. And whilst an objective observer might well think the provision could have been better drafted, that was not enough to allow the court to depart from the clear language of the phrase. One of the other judges, Lord Justice Nugee, who in fact was the judge in the Sterling case, agreed that there was no basis for concluding that a drafting mistake had been made, and he relied on the fact the drafter evidently took the language directly from the predecessor provision. Now, this case appears to row back from the relaxation in the Sterling case of the exacting threshold test, and is consistent with the view that if the provision is workable and not absurd or illogical, it won't be corrected simply to make its application more practical and reasonable in the circumstances. Now back to Jen.
So I'm going to move on to look at the fourth example of the court trying to help resolve mistakes, which is the remedy of rectification. Now, rectification obviously doesn't correct a mistake in the transaction itself, but corrects a mistake in the way the transaction has been expressed in writing. And it, in effect, rewrites history, so the document is treated as having always accorded with the intentions of those who executed the document. And it's the main method used for correcting pension scheme mistakes, which have unintentionally benefited members and can't be unwound because of the restrictions in the amendment power, or either Section 67 of the Pensions Act comes in to protect past service benefits. And also you can't use corrective construction that Paul has been talking about because the mistakes in the document, like the cherry trees case, are too extensive to be corrected in this way. Now, the test for rectification has been clarified in FSHC Group Holdings and GLAS Trust Corporation, and you can break it down into three main elements. Firstly, have the parties got a common continuing intention, whether or not amounting to an agreement in respect of a particular matter in the document to be rectified. Now, this is a subjective test, turning on what the parties who have the amendment power thought and did at the time. Did this common intention continue up to the time of the execution of the document sought to be rectified? And lastly, by mistake, did the document not reflect that common intention? I'm not going to go into debating the test in this seminar, but what I do want to highlight is that the remedy of rectification has its limits because it is an equitable discretionary remedy. So it's in the power of the court whether or not to grant it. And it's said to be cautiously watched and jealously guarded. Now, the process of rectification is time consuming and expensive because the court needs convincing proof that the document did not reflect the party's intentions. So the parties need to gather evidence to establish the grounds for rectification. And as is evidenced by the recent cases of Univar, so it was in 2020, which involved a 14-day trial with 16 witnesses, and the IBM case heard in 2012 on the topic of rectification, which involved 13 days of court time and 20 witnesses, it's obviously a substantive claim to bring to convince the court that a document needs to be rectified. But Paul includes some helpful pointers in his book guiding the search for evidence and what you need to look for in order to support a claim for rectification. Now, even if the evidence satisfies the conditions for rectification, the court, as I said, has got a discretion as to whether or not to grant this remedy, and the court may refuse to grant it where there is an equitable defence that comes into play. So, for example, you may have a defence based on late cheese, which is where there's a substantial period of delay in bringing the rectification claim from when the mistake was first discovered. This may bar the remedy on the ground that it renders it then inequitable to grant rectification. Alternatively, you may have a defence of bona fide purchaser, where rectification will not be granted, where that operates to the detriment of a bona fide purchaser for value. And that defence was attempted in the recent case of Mitchells and Butler, but it was rejected by Mr. Justice Trower on the basis that the employer, said to be the bona fide purchaser in that case, was not the purchaser in the relevant sense because it was just a substituted and successor employer to the pension scheme. Another way in which the courts are trying to be helpful using this remedy is that it can grant rectification on terms. So it can carve out a concession in the rectification order to any members affected by the amendment. So, for example, in the Conacher Minolta and Applegate case, the rectification was granted, but on terms that preserved the right of individual members to apply to court if they were faced with a claim from the scheme to repay any benefits based on the order for rectification. Now, the last thing I wanted to talk about on this topic is the use of summary judgment. It's become increasingly common to bring a claim for rectification using the Part 24 rule to apply for summary judgment. And this is another example of the courts being practical and allowing the correction of mistakes if there's no real prospect of the rectification claim being successfully defended on the evidence, and there's no other reason why the case should be disposed of at trial. And it's used if it's clear on the documents that there's been a mistake and it's clear what the parties intended the document to say. And this helps to avoid the significant costs and time of a rectification trial. Now, this is available whether the claim is commenced by way of Part 7 or Part 8, although if you're looking at a Part 8 claim, it's best to apply for a disposal hearing, as suggested by Chief Master Marsh in Sovereign Trustees and Lewis, rather than a Part 24 summary judgment application. It involves the court looking at a confidential opinion from counsel for the representative beneficiary, setting out the reasons why they have advised the beneficiary not to consent to the application. And this confidential approach has been endorsed by a string of cases decided by Chief Master Marsh, including the recent case of SPS Technologies and Moyet, heard in 2020. And the court will review the rectification proposed, the evidence submitted, and want to see that the representative beneficiary and their legal team have explored all reasonable lines of investigation. Now, usually the summary judgment application is determined at a hearing, so the court can be assisted by oral submissions as it works through the mountain of evidence. A public hearing will also serve to dispel any concerns from the members that there's been a deal done in the dark corner, as Mr. Justice Norris mentioned in Girls' Day School Trust and GDST Pension Trustees Limited. But where the issues are not complex and the evidence clear, an application could be disposed of without a hearing. Again, in the case of the Girls' Day School Trust, Mr. Justice Norris said that the publicity of a written judgment may achieve more than the delivery of an oral judgment in an empty courtroom. Although in that case, notice must be given to the members of any final order or any hearing date, if that is the direction you're going down, to allow the members to make submissions if necessary. I'll hand back to Paul to look at the fifth example of the courts trying to help.
Thank you. The equitable maxim, equity treats as done that which ought to be done, dates back to the early 18th century and has its most frequent application in the case of contracts, where equity will treat a contract to do a thing as if the thing were already done, although only in favour of persons entitled to enforce the contract and not in favour of volunteers. Now, in this context, its best known application is the doctrine of Walsh and Lonsdale, where a specifically enforceable agreement for a lease was held to take effect in equity as a completed lease before the requisite formalities for executing it had been satisfied. Now, the maxim had been applied in pensions cases to validate defective documents where the parties were under a duty to execute them, as opposed to a mere power, Davis v. Wallington again, and Harwood, Smart and Coles. However, the case I want to concentrate on is HR Trustees Limited and Wembley, where the judge went further in applying the maxim to validate an amendment which otherwise fell foul of the formality requirements of the amendment power. At that time, the time of its decision, the decision came out, it was thought to have made a significant inroad into the principle that amendments had to comply strictly with their requirements, but subsequent cases, as we'll see, have sought to row back from it. The scheme in the Wembley case contained an amendment power which permitted the employer to issue a written authority to the trustees to amend, following which the trustees were required to make a declaration of the amendment signed by all of them. The trustee body, which comprised of 5 individuals, had formally resolved to amend the scheme to change the rate of pension increases, benefits accruing after the 6th of April 2000. And that decision was made at 2 trustee meetings, one held in November 1999, which was attended by 4 of the trustees, and one in January 2000, attended by all 5 of the trustees. And after that, the scheme's insurer produced a document called a Scheme Amendment Authority, which was intended to put the trustees' decision into formal effect. That authority was signed at the July 2000 trustee meeting by the 4 trustees present, and the company secretary signed on behalf of the employer. The absent trustee, however, did not sign the authority because of an administrative oversight. It was accepted she would have signed the authority had she been asked, and she remained willing to sign it if required to do so by the court. Having rejected the employer's arguments as to why the amendment power should be construed to validate the amendment, the judge held that the amendment nevertheless was effective by applying the equitable maxim, because, he said, the trustees had already validly exercised their discretion to make the amendment authorised by the employer at the November 1999 and January 2000 trustee meetings. And having done so, the trustees were then obliged to make the appropriate declaration in a particular form and could have been compelled on behalf of the members who were not volunteers to specifically perform their exercise of the power. The judge went on to say, it may be that there has never been before a case on all fours with the present, but law and equity would be made to look ridiculous if it were powerless to correct what has been an obvious administrative error like the one made in this case, a sentiment sadly lacking from other cases where judges have not corrected pension scheme mistakes. The judge said that none of the scheme members whose benefits may have been adversely affected by the amendment had reason to feel aggrieved because they'd been notified of the change at the time and never expected to accrue rights on any other basis. The judge therefore held that the amendment was valid to amend benefits with effect from July 2000. Now, this decision has been regarded as controversial and the scope of its application is unclear. Could it, for example, be applied in cases of non-execution rather than merely defective execution? Was an attempt to make the amendment a prerequisite of the application of the maxim? And if so, how close to success must the attempt get? Was it a requirement for the trustees to have already resolved to make the amendment? What if the employer had authorised an amendment which was unequivocally for the benefit of the members, such that the only decision the trustees could properly have made in the circumstances was to approve it? Could the maxim apply at the earlier stage to treat the decision as having been made, as well as at the latter stage to treat the amendment as having been made? Now, since the Wembley case, a couple of attempts to apply the maxim to other defective pension scheme amendments have failed, although the bases on which the Wembley case was distinguished in those cases are not wholly satisfactory. In Briggs and Gleeds, the judge refused to apply the maxim to validate a defective amendment which operated to reduce members' benefits. The judge noted the potentially far-reaching implications of the Wembley case, given the application of the maxim didn't depend on the defective execution of the document, of the amendment. The judge was concerned this meant that a scheme's formally executed documents may not prove a reliable guide to its terms, and there could be confusion as to the applicable time of the amendment, where, for example, there'd been a delay between the trustees making the decision to amend and the execution of the amendment document, or where a decision had been made to change the amendment between those two times. The judge refused to apply the maxim because of the detrimental nature of the intended change to members' benefits. He considered the trustees should be treated as having done what they ought to have done only in favour of someone who would have been able to enforce the obligation. He said the trustees should not be taken to have made amendments against the interests of scheme members, where it was unrealistic to assume that the members would have compelled them to do so. In the other case, Burgess and Bick, in that case, the equitable maxim was invoked to cure a defective amendment which granted increases to members' benefits. In that case, the scheme rules gave the trustees power with the consent of the employer to amend the rules by documents signed by them and the employer. Trustees resolved to make the amendment at a trustee meeting, but the document wasn't signed and no other signed document was produced. The judge declined to apply the equitable maxim. He distinguished the Wembley case on the basis that the amendment power in his case didn't oblige the trustees to execute the amending document, but merely conferred a discretionary power. And he said the maxim had no application, as the court could not have compelled the trustees to make the amendment merely because they had in fact decided how it should be exercised. So it appears from those cases that the maxim will only be applied where the amendment was for the benefit of the members and where the amendment power itself created an obligation on the part of the trustees to make an amendment. But these restrictions on the application of the maxim are problematical. The attempt in the Briggs case to rely on the fact that the amendment in question was against the interests of the members ignores the fact that the amendment in issue in the Wembley case also reduced members' benefits, so not a valid ground of distinction. Moreover, the judge's analysis ignored the interests of the employer in there being a valid amendment, which would have reduced its liabilities to the scheme. The ability of the employer to compel the trustees to perfect the amendment should be sufficient to regard the amendment as having been made on the authority of Wembley. The fact that the amendment power in Burgess and Bick conferred only discretionary power on the trustees is not, I think, a relevant distinguishing feature, because in a previous case, the Best Trustees and Stewart case, the identically worded amendment power to that in the Wembley case had been held to give the trustees a discretion to refuse to make the amendment. So the reason why the maximum was applied in that case was that the trustees had already exercised that discretion and so had become obliged to comply with the formalities for making the amendment. The key question for the application of this maxim, which wasn't explored in either of those cases, was whether the circumstances surrounding the agreement between the trustees and the employer gave rise to a right on the part of the employer to compel the trustees to make the formal amendment in order for specific performance, which would allow the maxim to apply to treat the requisite formalities as having already been satisfied. And this requires the agreement to be supported by valuable consideration, as a contract contained in a deed which is without consideration will not be ordered to be specifically performed. Now, there's certainly an argument that where an amendment in question will affect the benefits of the members and has been the product of a negotiation between the trustees and the employer, a concluded agreement on the changes will be supported by valuable consideration, and it might take the form, for example, of professional costs which were incurred during the negotiations between the employer and the trustees. The employer and the trustees can accordingly strengthen the prospects for the application of the maxim should the amendment document fail to comply with the requisite formalities in some way by including in the amendment document a recital that they have agreed the changes contained in the document for valuable consideration and explaining the nature of that consideration. So I'll hand back now for final time to Jen.
So the last example we wanted to highlight of the courts coming to the assistance to correct mistakes is when it recognises that a member could be bound to accept the intended changes to a scheme as a matter of contract that it's entered into with the employer that also binds the trustee. And the leading case on this is Southwest Trains and Brightman, which was decided in 1999. It's a first instance decision of Mr. Justice Neuberger. There, the scheme members agreed by a binding contract with their employer to incorporate a number of allowances into their annual salary, with only part of that new salary being treated as pensionable. The trustee proposed to amend the rules of the scheme to give effect to this agreement, but this was challenged by the members, who said that under the rules as they stood, they were entitled to have all their salary being treated as pensionable. Mr. Justice Neuberger dismissed this challenge. He said there was an implied term in the contract that the members would not claim pensions at a higher level than had been agreed with the employer. So this agreement between the employer and the members, which affected the members' benefits, overrode the members' scheme rights, as it was then stated. The trustee could then refuse to pay the members a pension at a higher rate than that had been agreed with the employer. Now, this has subsequently been applied in the case of NUS officials and employees superannuation fund and pension ombudsman, which was the 2002 case, where a contract had been agreed between the members and the employer for a pay increase, but on the basis that that increase was not pensionable, and that was held to override the rights of the member under the scheme rules. And then there's a case of AF Blakemore and Son and Mackin, which recognised the Southwest Trains decision, but it ultimately remitted the matter back to the Ombudsman to determine if oral agreements were reached as a matter of fact between the relevant parties. So following Southwest Trains, the courts have allowed employers to agree individual contracts with members to change the terms of a pension scheme on an individual basis, rather than by way of scheme amendment, to avoid any complications around restrictions in amendment powers to change the scheme on a scheme-wide basis. But the case law has shown that an argument based on Southwest change is not always easy to make. So, for example, the parties need to show that they intended their rights to be governed by a contract separate from the terms of the scheme. And such an argument failed in HR Trustees in German, where there was held that there was no intention to create separate contractual relations, because in this case, the members were just told by the employer what it decided to do, so move members to defined contribution benefits, and they were presented with an almost a fait accompli. The explanatory booklet that the members were directed to look at stated that the scheme was governed by the trust deed and rules, and also the members were not asked to consent to the conversion of their benefits to defined contribution benefits. Also, in the case of Capita ATL and Galately, Mr. Justice Henderson held for various reasons that an announcement to members did not have contractual effect because there was no intention to create legal relations, and in any event, it wasn't clear who the parties to the contract were. However, a Southwest Trains type argument was successfully applied in an aspect of Briggs and Gleeds, where the employer argued that members were contractually bound to a number of changes made in various deeds, which were subsequently held to be invalid changes. But the employer's argument based on individual contracts with members was successful in relation to changes involving closing the defined benefit section, breaking the final salary link, and transferring the remaining members of that section to a new defined contribution section, which was not possible to do by scheme-wide amendments. So the reason why that was successful is because the members were offered membership of the defined contribution section in return for a one-off salary increase. And there the judge held that the 103 members concerned were contractually bound to this change. And this was for three main reasons. Firstly, there was an intention to create contractual relations. Behaviour could not be wholly explained by reference to the members' pre-existing rights. No one had an expectation that members were entitled to these salary increases. Second, that there was no requirement for informed consent in contract law. So the members didn't need to be informed of the restriction in the amendment power and saying, look at this, are you sure you're happy waiving your rights and entering into this contract with the employer? As was previously thought by Mr. Justice Arnold and HR Trustees in German. The judge said that contract law has already got its principles to vitiate contractual agreements. So, for example, mistake, misrepresentation, non-est factum type arguments. And thirdly, Section 91 of the Pensions Act 1995, where you can't generally assign, commute or surrender your pension rights, doesn't apply where there's doubt or dispute about the existence of the right in issue. So here it was held that the contract operated as a form of compromise where there was doubt about whether or not the transfer in question could break the final salary link. So it was held to operate outside Section 91 and could stand. So that brings us to the end of our examples of the court trying to help.
Lovely. Well, thank you. Thank you, Jenny. So what this talk, I think, shows is that there are a number of legal principles which exist for the correction of pension scheme mistakes, but that the courts have sought to control the application of those principles by setting a number of limitations to them. And it seems that the judge's willingness in the Wembley case to adapt law and equity to overcome obvious mistakes sadly remains the exception rather than the rule. So we've got 10 minutes or so left for questions or comments. I'll start by asking if there's anyone in the room who has any questions or comments they'd like to put. Yes.
Hi, Paul.
Hi.
Just one question. If you had a deed, hypothetically, where it described the benefits, but in a consolidation, they missed out the last two lines of the benefit, which said, and now deduct the earnings limits. Hypothetically. And then that wasn't noticed for another couple of consolidations. Under which principle would you think the best way to go would be?
Well,
It's shown to be a typo.
yeah, yes, yeah. I mean, the two principles in play there are corrective construction and rectification, and the contrast is that the case, all things being equal, on the way you say it, sounds like a clear case for rectification. The problem is that for many reasons to do with the fact that you can't have too much evidence for rectification, the range of investigations that are necessary means that it's an expensive task, and it also requires court proceedings. And although the courts have helped with summary judgment applications, etc., there's the need to bring in a representative beneficiary. They'll no doubt need to more than likely have to be a hearing. It's a lot of money. Corrective construction, on the other hand, as I said, does not require court proceedings if you've got robust enough legal advisors prepared to advise us that as a matter of construction, you can read those missing words into the consolidated deed, then that can be enough. That can be enough. But the question there is whether or not it overcomes the exacting threshold test. And it sounds to me like your case is getting nearer the obvious clerical error kind of case that the Court of Appeal in the Britvik case was prepared to accept as falling within the corrective construction provision. But there are other limitations, such as the cherry tree limitation. One has to look at if it's a part of a provision or whether it's a freestanding provision to see whether the corrective construction principle applies. So corrective construction is simpler and cheaper and quicker to effect, but it is more restrictive than rectification. But they're the two principles in play. Anyone else?
Jenny, Univar Trower, I think, when you were looking at some of the frames, said that the expensive contract can only reduce benefits provided in the scheme that could improve the benefits. Do you see any logic for that restriction on the expensive? The argument is
so just so I understand, he was saying that a member could individually agree with their employer to reduce their benefits rather than their pensionable benefits rather than increase them. I can't see any logic behind that, because it seems like it'd be in the interests of members to allow the mechanism to work where they increase their pensionable benefits. And from the case law that I've looked at, that's a novel restriction. I don't know if you've got any further thoughts.
Well, the only thing I'd add to that is that one of the things you need to be careful about with contracts that seek to reduce benefits is the application of Section 91 of the Pensions Act 1995, which renders void any agreement to surrender accrued rights to pensions benefits. The exception to that being where there is a genuine dispute as to what those rights are, and you've got Court of Appeal authority to the extent that would allow that agreement to be valid, notwithstanding Section 91. But no, I agree with you. It doesn't seem to me as a matter of principle that it should matter what the terms of the contract are. It's whether the contract is enforceable against the trustees, which is the relevant part.
I think he was wrong on that case, on that aspect. Yeah.
Anyone else? We haven't got any questions from the 75 people who are watching on Zoom. So either we've stunned everyone into submission or we've not left any questions open. Well, in that case, it only remains for me to thank those people watching online and the people in the room for attending. I wish you a very pleasant day. Thank you.